morning. Please be seated. We're here today for oral argument in case number CV130028, Reyes versus Frank Service and Trucking. These proceedings are being audio and video recorded, so we'd ask counsel to identify yourselves and your client for the record. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time if you choose to do so. We have conferenced this matter. We've read the briefs and have discussed the case, and we look forward to your argument. Pat, you may proceed.
Good morning. My name is Melinda Seconder, and I represent Defendant Appellant Cross Appellee Frank's Service and Trucking, LLC. I will attempt to reserve some time at least to respond to any arguments regarding the cross appeal. The issues we have raised on appeal involve costs awarded by the trial court. The first cost that I would like to discuss is the cost of videotaped depositions. Those were awarded by the trial court as the costs incurred in connection with taking a deposition. The trial court also awarded the cost of obtaining a paper transcript of the deposition. We have contended that that cost is not, the cost of the videotape deposition is not a cost of taking a deposition.
Let me ask you why. And let's assume they just requested the videotape deposition expenses and not the transcript expense. Why is that not a cost of taking a deposition? As you know, the rule recognizes, and Rule 30b-4, which really isn't in play here, talks about the methodology of who pays for what when there's both. I understand an argument that the trial court should exercise caution in awarding both, but I'm not sure I agree with the threshold proposition that videotape deposition expenses aren't expenses or aren't costs of depositions.
The reason being that the only reason to videotape a deposition is for its potential later use at trial. There could be several circumstances in which you might want to do that. You might think that the witness is going to leave, disappear. You might think that the witness has a condition, a situation in life that may cause the witness to be unable to appear at trial.
But is that so? At times, especially with a very lengthy written transcript, it'll be more expensive to order a written transcript than the videotaped version. And so couldn't counsel decide, I'm going to order the videotape just for my review and preparation for trial? I mean, I'm not sure that premise is always going to be true.
Well, I think the problem with it is that I don't know any trial attorneys who actually use a videotape deposition as opposed to a written transcript to prepare for trial. You often have to designate page and line numbers before trial to be read into trial. If you videotape a deposition and your purpose is, it's not discovery because you have the paper transcript as well that you can use to prepare for trial. What you're trying to do is save yourself the cost of locating the witness and bringing the witness to trial.
What if there is a legitimate concern that a witness may not be available? Isn't that kind of a reasonable thing to do, though, to order the video?
Then what you're doing is you're doing that for yourself to preserve the witness's testimony for trial. And if you look at the case of the Arizona Supreme Court opinion in Schroeder, there the plaintiff's counsel took the depositions of the plaintiff's expert witnesses and said that because if the defendants had deposed and the defendants had paid an expert witness fee, I get that expert witness fee paid to my client as a cost of taking a deposition. And the Supreme Court said, no, where you're taking the deposition to use at trial in lieu of calling your witness at trial, that's not the cost of taking. I
understand that it might not always be reasonable, and that would not be probably a cost that should be awarded. But if there is a circumstance, say where everybody agrees that this witness has a terminal illness, it makes sense to conduct a videotape deposition. Wouldn't there be some circumstances under which a videotape deposition would make sense and be reasonable?
But you'd be videotaping that deposition to use at trial, to present that witness's testimony at trial. That would be, then you'd be saying, I get the cost of presenting this witness. Under 12332A1, it wouldn't be recoverable. That's the cost of witnesses. You're trying to get it under the cost of taking a deposition, 12332 A2 or B. And it's not a cost of taking a deposition. It's the cost of preserving testimony for use at trial.
And I understand why you rely on Schroeder. If this record inalterably established that the only purpose of those videotapes was to use them at trial, they weren't used apparently, but I'm having trouble with that premise. I think trial preparation is another purpose. You could send the videotape to your experts, to your IME doctor. There are a lot of reasons you would order a videotape deposition, in my mind, to show your trial consultant, to conduct a mock jury, that have nothing to do with playing it at trial. And so I'm not sure on this record we can say that's the only reason a person would ever have a videotape deposition copy.
Well, these depositions were not even used at trial.
Right,
as far
but we
as
know that deposition transcripts don't have to be used at trial to be a cost, so.
Right, and the videotape ones were not, the ones that we've objected to were not as well. But now you're increasing costs unilaterally that you're now going to try to shift to the defendant who was found 51% liable while you were found 49% liable when you unilaterally decided you needed to videotape.
Well, that's why I think there's an issue of reasonableness in awarding both, but if I order a bunch of deposition transcripts that I never use at trial, that's the same policy argument you're making now, and yet we know those are recoverable costs.
But you've got two different copies of a deposition at this point. You've got a paper copy and a video.
I think that's your best argument. I don't.
And a video copy, and I don't see how it's reasonable to have both, and yet the trial court awarded it all. We didn't object to the costs of the paper transcripts because we knew under the case law that those were recoverable as costs of taking depositions. We did object to the videotape ones because there's no Arizona court holding that they're costs of taking depositions.
And counsel, did those charges, those videotape charges, were those incurred prior to the offer of judgment? Do you recall?
Some of them were, I believe. That's itemized in our reply brief. Which costs in each of the categories were incurred pre the offer of judgment and which were incurred after the offer of judgment. Those are all set forth in our reply brief and itemized.
So is it your position that that would make a difference then if we were to disallow, or if the trial court would have disallowed the videotape testimony, that would make a difference?
Yes.
As far as the Rule 68 calculation?
Yes, I do. Also, then the trial court awarded the costs for travel to depositions inside the state of Arizona. The two cases on point are Young's Market Supreme Court case of 1943, which held that the cost of a defendant having to travel to San Francisco to be present for the deposition of the plaintiff's expert, where the plaintiff was going to present that expert by way of deposition at trial, was a recoverable cost. The Bennett case in paragraph 37, is a 2010 appellate case, said that, citing Young's Market, made a distinction between travel costs out of state and travel costs in state. No Arizona appellate or Supreme Court opinion has held that travel costs to attend a deposition in Arizona are recoverable as a cost of taking deposition.
What about the DeMontenay case? Doesn't it say just that? It talks about lawyer travel expenses coming from Phoenix to Yuma for depositions were recoverable under the statute.
The DeMontenay case is that the opinion that says that is the 1984 appellate opinion. In 1985, the Supreme Court reversed that opinion on the merits, thus vacating the award of costs. And thus, the Bennett opinion, which postdates the Montenay appellate opinion, in which costs award was vacated.
But DeMontenay was only vacated on other grounds. The Supreme Court didn't specifically discuss the cost issue.
No, they didn't need to because it would be vacated automatically. because no longer was the party the successful party, because it was
Cost
vacated.
award would be vacated, but the holding of the Court of Appeals wouldn't be overturned on the issue of costs. The Court of Appeals was overturned on other grounds, and we routinely still rely on grounds that were not vacated by the Supreme Court.
Well, the cost award itself was vacated, so I don't see how you could place any reliance upon the discussion of the costs, where the Supreme Court knew the cost award would be vacated anyway, and as a practical matter, didn't need to discuss the cost at that point, and where you have the 2010 Bennett opinion that goes against what de Montenay held.
So, I mean, Bennett never cites de Montenay, and I understand why you would rely on Bennett, but you have to read a lot in by inference, because they never say anything about in-state deposition costs. They just say that the record does not reflect that the depositions were taken outside of Arizona.
Right.
That's a pretty thin read for saying in-state deposition costs therefore are not recoverable. I mean, just in that case, they're making that observation.
Right, but why would they make that observation if it was not significant to their holding? I take it that there would have been, if travel costs were recoverable, whether it was in-state or out-of-state, Bennett wouldn't have made that distinction.
Counsel, just as a practical matter, what would be the policy reason for differentiating between in-state, out-of-state? I mean, Phoenix to Yuma versus Phoenix to Blythe, California.
I have absolutely no good answer for you, and I have thought about that. I note that Young's Market didn't explain why out-of-state was important to it, but it did note that the foreign jurisdiction was important to its decision. Bennett didn't say why in-state versus out-of-state. Made a point in its analysis of the cost issue there in paragraph 37. So I honestly, I'll be frank, I can't come up with a good reason. The trial court also awarded certain costs as taxable costs, saying that there was an agreement that the mediation fee or the videotape deposition of Dr. Wilkinson would be paid for by the party, the losing party. And yet, all there is an agreement to mediate with both parties to share the cost equally. There's an agreement, no objection to videotaping the deposition of Dr. Wilkinson. But what's lacking in this record is any agreement that those fees were to be considered a taxable cost. There's a distinction between agreeing that you're going to mediate with each party to pay half the mediation fees and an agreement that the losing party would pay the other party's half of the mediation fees.
How about if there'd just been no agreement at all? The parties just go to mediation with no agreement. Would they be taxable? Would it be a taxable cost? In that
No.
event?
It's not listed in 12332. It's not listed as a taxable cost. The agreement, the mediation fees aren't listed there as a taxable cost. And thus, unless there's an agreement that the parties agree we're going to go to mediation, we'll each pay half up front, and the losing party will pay all of it, and we agree that that's going to be a taxable cost. Without that second part of the agreement, you can't infer that parties who agree to go to mediation to split the cost have now agreed to transfer that cost, turn that cost into a taxable cost.
It seems to me, though, that second part is reading something into the statute that's not there. 12332A6 says costs in the Superior Court include other disbursements that are made or incurred pursuant to an agreement of the parties. It doesn't say an agreement of the parties that these will be taxable costs. It's just disbursements incurred pursuant to an agreement of the parties. Why isn't this that?
It's not because they each agreed to incur half of it. They had a specific agreement as to how the fee for the mediation would be split, half and half. There's no further agreement that under that section of the statute it would be treated as a taxable cost. You're now taking the agreement one step further, which is if you agree to split costs, suddenly that's now a taxable cost. And Bennett held that where there wasn't any evidence of an agreement to treat them as taxable costs, it's not treatable as taxable costs, and the trial court errs in so doing. And that's why this is not a taxable cost. I'd like to reserve the remainder of my time unless you have other questions. Thank you.
May it please the court, my name is David Abney. I'm here today on behalf of Hugo Reyes, the appellant, pardon me, the appellee. I'm sorry, I don't get to be.
Get over there.
I know. In fact, I sat there when I came in and had to be evicted. I know this is probably not the most exciting case in the world as far as newspaper interest or magazines and television cameras aren't here, but there are a lot of little issues here that come up again and again and again. So, and I hope the court rules in favor of my client, but whatever you do, this would be a good decision to publish because of these little things that lawyers are always asking each other. Well, do I get the video? What about travel? You know, all these issues that come over and over, and there's no solid Arizona guidance yet, but there can be.
I'm glad you mentioned that, Mr. Abney, because and maybe we can jump right into videotape testimony, and you can help enlighten me a little bit about your view of that. So let's say we were to affirm, and we were to affirm that the awarding of dual costs, essentially the paper and the video for the cost of a deposition. Are you nervous about that holding at all going forward? I mean, is it, in terms of policy ramifications going down the road, as far as that, as a matter of course, almost that you're entitled to those types of duplicate costs, or are you suggesting that would be highly discretionary still to the trial court whether you're entitled to receive those?
I don't see why it would be discretionary. I've done a lot of these video depositions or sat in on them, a lot of them, and it's always the videography and the court reporter there. They're doing the same job. It always seems a little weird to me, but nobody does just the video alone. I've never seen that. And I suppose you could, but you always want to have that transcript. So no, I would not mind being hoisted by the same petard as everybody else. That's fine with me.
In that being the case, then are you surprised or not? I guess are you surprised that there's no case yet? I mean, nobody's challenged like a duplicate award of or maybe nobody traditionally seeks a dual award of paper and video.
Well, I guess a little bit, but this is one of those weird cases where we're on the knife edge. I mean, dollars and cents matter here a great deal. You eliminate a certain category, and all of a sudden, the Rule 68 situation flips. So I'm surprised to some degree, sure. It's just an old. But now it's just the way you do it. You get the video, you get the transcript, you have both available. And there's so many reasons to get the video. It keeps the witness honest. You have that in your back pocket in case the witness starts acting strange at trial. Plus,
You have that with the transcript as well?
it does not have the same impact.
But it is still optional for the parties to make the decision to do the video.
Sure. At our law firm, we video just about everything. And the reason is we have discovered that juries are not real impressed with a dry recitation of a transcript, question, answer, it puts them to sleep. But if you get the video and you show the witness there, you ask the question and the witness hesitates. And the eyes dart to the right, he looks up, looks down, hems and haws, and finally answers the question. None of that appears in the written transcript. Well, the jury gets the impression that witness has something hidden, is not being as forthright. It's an incredible thing. And what you do at trial, you get the videographer prepares these excerpts, and you go over those during the breaks and before trial on certain days, so everybody knows what's going to be on the screen if you use it, and everybody agrees that you're editing fairly, and it's a very, very powerful tool.
But if that's the use, and that's what Ms. Sikander is saying too, why does that not run afoul of Schroeder when it comes to your own witnesses? Because Schroeder holds that you can't seek reimbursement as taxable costs for deposition testimony by your own witness that you're going to use at trial in lieu of their live appearance.
I don't know. I mean, if they're noticing they're requiring you to go to a deposition of your own witnesses, they notice the deposition. I don't know why that wouldn't be a recoverable taxable cost. Seems sensible to me.
That's the Supreme Court, so I can't disagree with them, but.
Well, I'm not
but-
sure that this case involves those kinds of witnesses, videotaping and that sort of thing, but I don't see why that would matter.
But if it's something that's primarily or almost strictly for your benefit, it's not necessary, but for your benefit, why is it different than, it would be really helpful if we bring in a mock jury and we go to the expense of having a mock jury? That would be really helpful.
But that's not the cost of taking a deposition. That's the cost of just general trial preparation. And that
Taking the deposition arguably is getting the transcript. If you're going beyond that to do something that you think benefits your case, why is it necessarily, should we build that into the system and just say, yeah, everybody, you should just automatically do this and it will be a recoverable cost?
You mean mock juries? No. Depositions, yes.
With the video
Yeah,
deposition?
absolutely. It's the wave of today, no longer the wave of tomorrow. It's used all the time and used very well. And you may not actually have to use it. Just the threat of hanging over in the background, it tends to keep witnesses more honest, I believe, than they would be simply with the written page hanging over
Is there any kind of issue with one side not having resources to go this route, and I'm going to be stuck with only having the only costs will be taxable are my deposition transcripts? The other side that has these deep pockets can do the video, and
Well,
I have to pay that.
Well, once you talk about deep pockets, you're talking about people that are not my clients ever. I mean, my clients have no pockets at all, and we, as a law firm and other plaintiffs' law firms, are willing to do this, to get these video depositions along with the paper, and because they are so valuable in so many ways. Trial preparation, use at trial, it's just a wonder. I'd never heard of using them with mock juries, which seems like a great idea to me. The only mock juries I've seen are people play roles, but a video deposition in a mock jury sounds like a wonderful idea.
Couldn't there, counsel, be a wide variety or range of the costs that you might incur in such thing? I'm just envisioning perhaps you could put the iPhone sitting on the table. That could record the whole thing. It could record the whole deposition, as opposed to a highly sophisticated equipment that's very reliable and is going to timestamp everything throughout, and it's going to give you the ability to call back instantly to whatever minute you need. I mean, that could run from thousands of dollars to $20 or $50 for.
It can get expensive, and it's funny that you asked that, because when I was driving over here, I thought about why do we use videographers, and I think it's a matter of distrust. Lawyers just don't trust the other lawyer to record things properly. And if we trusted each other implicitly, we would, go ahead, use your iPhone, we could record this. But there's so much, what about the angle? Is it full screen? Is it narrow? What else are you showing? How much are you recording? How good is your recorder? So, I mean, we use the videographer as a matter of keeping everything honest. And even though it's more expensive, it works. We're talking about in-state, out-of-state depositions. I think there's Bullhead City, and across the bridge is Laughlin. Is that how it works? Pretty sure, if my geography's right. Well, why would it be one cost in Bullhead City? You cross the bridge, go to one of the casinos, rent a room, and do a deposition, and it's a different cost. Doesn't make any sense to me. I mean, you ought to be able to get the travel costs.
Okay, tell us why, I know you weren't the trial lawyer, that convoluted procedure was used. I cannot figure rhyme or reason about adding in the gas, taking out the gas, and it raises question marks and red flags when people try to do things like that, because it usually signifies they're trying to get more than they would be entitled to otherwise. And do you have any insight on that?
I do, and pardon me if it's not perfect insight. I talked with the lawyers. It was Silas Schultz and Mike Rollins. Said, why in the world did you do this? Because you add in, you take out the same thing. It's something about the lawyers pay for the gas, so they just wanted to have some sort of precise mechanism for identifying the cost of the gasoline. It was the lawyers paying out of their own pocket, and they wanted to get reimbursed immediately for that gas expenditure. That's why they did it. It seems dumb as dirt to me. It didn't make any sense. Because I looked at it the first time, I thought, well, they are doing something sneaky here. And then I went through it and I asked them, and they're not. They're just doing something really dumb. The judge had before him a dispute about whether there was an agreement to mediate, videotape, use an interpreter. And the judge worked through what the statements that the various parties had made through their attorneys and said, well, here's my decision. I've decided that you guys did agree, in fact, to these sorts of things, and that's my decision. And I believe that would be entitled to deference on appeal under the abuse of discretion standard. If there's a specific finding, we should defer to
Why
it.
isn't the agreement between the parties lead to the opposite conclusion, that they specifically agreed that we're going to shoulder the costs of these of going to mediation?
An implicit agreement of some nature?
Right.
Well, you could go that path. You could go, there's an implicit agreement that you're gonna pay.
Well, it wasn't an explicit agreement that we're each going to pay for half the cost of mediation.
Of that part, and then what happens then at the end, who gets reimbursed for what they actually paid out of their own pocket. There was no explicit agreement on that. The judge instead found it was implicit from what he had heard and from the circumstances. So I mean, it's one of those things.
But it's implicit that the parties would treat that as a taxable cost for purposes of Rule 68.
You could go that way. You could go the other way. And the beauty of the rare occasion when I actually have abuse of discretion on my side is you're supposed to go the way where you uphold what the trial judge did.
But what are we upholding? Are we saying that he believed that the parties intended that these would be taxable costs, just based on simply the language of the agreement?
He believed that after listening to the parties about what they had decided, that they had agreed to incur the costs, and he supported that agreement by saying, well, there's necessarily, that's exactly how you would do it. It's a matter of logical necessity. The court may say, hokum, or the court may say, great. In a situation like this, the court should probably say, okay, we'll give them the benefit of the doubt. I think that's what the abuse of discretion
I
standard
guess I'm
is.
just a little bit puzzled as to what we're giving the benefit of the doubt to. There wasn't a credibility determination that he made based on one party saying, I intended that this would be a taxable cost, and the other one saying, no, we didn't intend that. He's simply looking at the same thing we would be looking at. So I'm a little bit.
Well, he's also listing the representations of counsel saying this and what other counsel saying that, and deciding based upon what they have said.
We thought this would be a taxable cost. The
No,
parties thought.
they did not say that. They said that they thought that they had agreed to have these things done, mediation, the interpreter, and videotaping, and then after everything settles, they say, well, it's implicit from this. One side said it's implicit from this that the cost would be a taxable kind of thing, and the other side saying it's implicit from this the cost would not be a taxable thing, and the judge had to decide which implication to follow.
Counsel, are you aware of any cases anywhere that address mediation as a cost, as a taxable cost?
No. I looked, and if it's there, I failed to find it.
But, I mean, but isn't it the case that with private mediation, I mean, absent extraordinary circumstances, I mean, generally the mediator's not going to go forward unless he has an agreement, if you will, that both sides are going to. He's going to get paid. He or she is going to get paid.
The mediators are.
Well, they need that
good at
agreement, but that's an agreement to pay, which and that's what I'm struggling with, I guess, is that's an agreement to get paid. Obviously, no private mediator does it for free, except it maybe on occasion to do it pro bono. But they want to get paid, so there's always going to be an underlying agreement. I just don't know the ramifications. Again, similar to talking about videotaping, here they're on the threshold of another sort of cutting issue. If we were to adopt a policy that mediation costs are taxable costs, I'm not sure of the ramifications of that.
The videotaping I don't see is really on the cutting edge. I think it's an important, somewhat unsettled issue at the appellate level. At the trial level, everybody's figured out what to do with it. The mediator thing, and mediators, of course, are in it for the money, and they are very, very good at getting that money before they do anything. But the thing here that lifts it out of mediation and murkiness is the trial judge's examination of the circumstances and his conclusion that there was, in fact, at least implicitly, an agreement. I think that takes this out of the murk. Oh, well, I guess I don't get to do anything about the interpreter. We didn't really discuss that. So, are there any other questions? I think I've addressed the points.
Curious
that came
about
up.
the jury instruction. And why was that jury instruction significant? The one that was not given. How would it have been significant?
It was a very close case on liability, and our position is that allowing a fuller instruction on negligence per se might have tipped the balance enough that it would be a far less close case. It would be a better case for our client.
In
I was
terms
a little
of the allocation of fault.
Yes, Your Honor.
I was a little confused to call it a per se negligence instruction when the instruction also talks about you shouldn't do this unless it's reasonable.
I know.
So how is that different than just instructing on the defendant has to act reasonably?
Well, there were other factors in the statute of position, movement, and so forth that would.
But all of the factors, unless reasonable under the circumstances, essentially. So it didn't seem like it was a dynamite instruction that would necessarily change the outcome.
It's not a dynamite instruction other than in the sense that it's blowing up in my face right now. It's not my strongest argument, and I think I made the best I could of it in my briefing, and would love not to talk about it anymore. Are there any other things that the court would like to address?
Well, since you have time, you were talking about the judge's ruling taking it out of the murk, and I was just looking at his ruling on the mediation issue, and I'm not sure it does take it out of the murk. As I read his ruling, all he finds is that the parties agreed to incur the mediation costs, and then he interprets an agreement as being sufficient under 12332A6. In essence, as I read his ruling, saying anytime the parties agree to incur a cost, then it becomes a taxable cost. I'm not sure I agree with that.
I think that any time would be too strong, but in this particular time, after looking at all the circumstances, I think it's a fair enough decision. It's on the borderline. Reasonable people could certainly differ on this one, but I believe that the standard is, oh my gosh, uphold the award of costs if there's any reasonable basis, and that is a reasonable basis. It may not be one that would win a law school competition, but it is reasonable. Are there any other questions?
Well, I've got you there.
Sure.
Just on the same issue, I mean, the statute specifically talks about costs of a deposition.
Yes.
So it doesn't specifically talk about, and I think that's what opposing counsel is drawing that distinction. So I think it's easier to get there on the videotape deposition than it is with the mediation because it's the type of cost that's contemplated under the statute. And since the mediation is not necessarily a type of cost that's contemplated under the statute, shouldn't there be an express agreement as opposed to just there's an agreement that we're going to each pay to get this mediation underway?
Well, I think an implied agreement that the trial court is comfortable with actually exists is good enough under the circumstances of this particular case.
The implication is that that's what's contemplated under the statute.
That is an implication. Plus,
that's where I'm wondering why we would need to defer to that aspect of it.
Well, I think the need to defer comes out of the case law that in this type of situation when you're dealing with a cost, the trial judge is making sometimes a hard decision and under hurried circumstances and doing the best the trial judge can. So I think that's why that standard exists. Well, thank you very much. I appreciate it.
I'd just like to make a couple of points, if I might. With respect to the mediation costs being taxable costs, I believe that because the statute doesn't hold that they are taxable costs, that there's a de novo review and that this court need not defer to anything the trial court said about that. It's clear there's no express agreement that those costs would be taxable costs and that the losing party would pay the other parties 1/2 of those mediation fees. In fact, the parties are in complete opposite corners with respect to whether there was an implicit agreement. The defendants say there was no agreement whatsoever to treat those costs as taxable costs. So it would be a de novo review. The same with respect to any agreement with respect to an interpreter. There's no evidence of an agreement with respect to an interpreter. They've argued that there was an agreement, and thus the interpreter's fee should come in that last category of taxable costs. At the trial court level, they argued that the cost of the interpreter was the cost of a witness. We argued it was not. The trial court found it was a cost of a witness. On appeal, they argued it's the cost of taking a deposition. Complete change in theory. And we have responded to that in our reply brief. And with respect to Judge Brown's prior question as to the videotape deposition costs to which we have objected, they were all pre the offer of judgment. And we will stand on our answering brief with respect to the cross appeal. We believe that Hutto controls and that this statute's no different than the statute at issue in Hutto, where the court held it did not support a negligence per se instruction. And unless you have any further questions.
Thank you. Thank you both for your arguments. We will take this matter under advisement and issue a decision in due course. We will take a brief recess to prepare the courtroom for the next argument.
Well, that was fun. How are your boys? Oh, that's good. Stu's college. In the sophomore year at George Mason. They still regard me as the world's biggest idiot. I'm hopeful in a few years that'll change.
Eventually, they come around.
Good.
Yeah.
Thanks for asking. How are your kids doing?
Good. We're heading up to Mimi's graduation on Wednesday.
Oh, good. What field did she get in?
Public health.
Good.
She wants to give the.
She's a very bright kid.